Today we're going to be looking at natural law, the Nuremberg trials, and international justice. After the atrocities committed by the Nazis in World War II were exposed, the Allies agreed that the perpetrators should be put on trial. However, there was a problem. The actions of these perpetrators were perfectly legal under the laws of Nazi Germany. Looking outside the borders of Nazi Germany to Poland or the Soviet Union, where many of these atrocities were committed, the local law was focused on individual cases of murder and abuse. Their national legal systems were simply not able to deal with the international nature of these crimes or the scale of horrors committed by the Nazis. If they were to be tried at all, then, it was necessary to try the accused outside any existing body of state law. This lecture will examine the options that the Nuremberg judges had available to legitimize the court, analyze the drafting of the Charter of the International Military Tribunal at Nuremberg, along with its text, and consider how this has influenced the development of post-war international justice. Throughout, it will consider the sources the judges used to explain how they surmounted this problem. This will demonstrate that the judges of the International Military Tribunal at Nuremberg revived natural law theory, a previously dormant legal philosophy which thereafter became the basis for international criminal trials to the present. International law, as it had developed up to 1945, was based on state sovereignty. The totality of international treaties up to World War II were between states or groups of states, and presumed that states had exclusive jurisdiction within their borders. Given these precedents, the IMT needed to overcome the tradition of state sovereignty and attempted to do so by delving into the history of legal philosophy to find a theory that could establish a basis for the court and the trials. What they found were natural law theory and universal jurisdiction. British and American judges believed that any court set to try the accused Nazi perpetrators required a charter that dealt with this issue. The concepts they incorporated into the charter have weakened the idea that states are absolutely sovereign, established international jurisdiction, and have allowed for subsequent prosecution of war crimes around the world to this day. Natural law is a body of law which is inherent to the nature of the universe, and specifically the nature of humanity. According to this view, any human can and should be able to deduce these laws merely from experience and observation, regardless of state or culture. Where did this idea come from? Ancient philosophers like Plato and Aristotle never fleshed out the concept of natural law. The first place that we see it conceptually defined is in Roman Catholic philosophy by Thomas Aquinas. Writing in his Summa Theologica in the 12th century, he formalized the idea that laws could be derived from nature. In his religious context, however, he declared that nature itself is the creation of God, and natural law was really just another form of God's law. But the judges tasked with chartering the International Military Tribunal were seeking secular natural law, so the theory as developed by Aquinas would not suffice. To establish natural law as a basis for the IMT, they looked to the 17th century Netherlands and the work of Hugo Grotius, who accepted Aquinas' religious definition, but later recognized that these laws could be deduced without reference to religion or culture. Thus, secular natural law theory was born. Secular natural law theory was further developed by Thomas Hobbes, the 17th century English philosopher. He proposed 19 specific laws that he claimed to have derived from nature, specifically the nature of humanity itself. Those most applicable to the IMT included Law 1, which asserted that everyone at all times must seek peace and only resort to war when necessary for self-defense. Law 9, everyone must acknowledge everyone else to be his equal in nature, with equal natural rights. And Law 16, every controversy concerning the violation of these laws must be submitted to some just arbiter. Still, there were theoretical alternatives, such as relativism, which is the concept that laws are just another manifestation of culture, much like regional food style, clothing style, and so forth. In this view, all cultures are equal, and therefore all manifestations of culture, including laws, are also fundamentally neutral. But that would mean that the laws of Nazi Germany, too, were simply manifestations of Nazi culture, and therefore no one could judge them as anything but neutral manifestations of culture. Therefore, in this view, the atrocities of the Nazis, which were almost universally recognized as evil, could not be prosecuted. The most accepted view of law prior to the Nuremberg trials was known as positivism. Applied to the legal field, it stated that a law is merely a rule promulgated by a final authority in a state, whether that be a text like the Constitution, a legislative body, a monarch, or a dictator. So in this view, sovereignty, again, was absolute. It did not solve the dilemma of how the Nazi atrocities could be prosecuted. Yet, beyond this, there were even other alternatives beyond the range of law, one being to summarily execute the perpetrators. Both Winston Churchill and Henry Morgenthau, the U.S. Secretary of the Treasury at the time, proposed shooting leading Nazis. But that would have been perilously close to what the Nazis themselves did. The perpetrators, too, simply shot people that they didn't like. The Soviets desired trials for propaganda purposes, but with the certainty that the accused would be convicted and shot. The American and British Army legal officers wanted genuine trials, but felt that they first required a charter that allowed for the suppression of state sovereignty in these cases. This would require a re-examination of legal philosophy that ultimately led to the revival of natural law theory. So, after some deliberation between British and American judges, natural law was accepted as the basis for the Nuremberg trials. The Allies determined that trials were necessary and that the judges adopted a legal theory, but the question of what kind of crimes would be tried remained. This was delimited in Section 2, Article 6 of the Charter. The first class of crimes to be tried were crimes against peace, which subsumed the waging of aggressive wars of conquest, corresponding to Hobbes' first law. The next class were war crimes, described as the violations of the ordinary customs of war. The final class were crimes against humanity, the very name of which was taken from natural law theory and the nature of humanity itself. By late 1945, the judges had adopted natural law theory as the basis of the trials, and the categories of crimes that they would try had been delineated. But how could the court establish its jurisdiction? Arguing from natural law theory, the Charter asserted in subsection C of Article 6 that such crimes were subject to universal jurisdiction. Natural laws are universal in scope, and therefore jurisdiction is equally universal. According to the Charter, this was whether or not in violation of domestic laws of the country where perpetrated. Direct quote. The perpetrators could be tried by any state or collection of states, and at this time by the IMT. In sum, natural law and universal jurisdiction are referred to both explicitly and implicitly in the IMT Charter. Therefore, the IMT Charter established a legal justification for overriding state sovereignty and establishing international jurisdiction, universal jurisdiction even, so that the trial court could be convened. This is a direct quote from the Charter. It said that the very essence of the Charter is that individuals have international duties which transcend the national obligations of obedience imposed by the individual state. He who violates the laws of war cannot obtain immunity while acting in pursuance of the authority of the state, if the state in authorizing action moves outside its competence under international law. So there you have it, the basic idea of universal jurisdiction, which was necessary to convene the IMT. So, when the Charter was publicized, its foundation of natural law theory was surprisingly well received around the globe. The United Nations adopted natural law in its foundational documents, specifically in Resolution 95, adopted by the UN at the conclusion of the trials. Clearly, this application of natural law theory was successful in its time. This success was initially muted, however, by a long series of pauses before it was applied again. It was revived when, over Argentine objections, Israeli agents arrested Adolf Eichmann, a major perpetrator of the Holocaust, and took him to Israel, where he was tried for violations of natural law, crimes against humanity, under a court claiming universal jurisdiction. This trial can be considered both an extension of the principles of the IMT and evidence that the concepts of the Charter had not died. Yet there was an even longer pause from 1960 to 1994. In 1994, the world witnessed some grave violations of human rights, such as the then ongoing genocide of Bosnian Muslims in Yugoslavia and the genocide of the Tutsi by the Hutus in Rwanda. In both cases, the Security Council of the United Nations established ad hoc military tribunals to try the cases based on natural law with universal jurisdiction. The success of these tribunals prompted the UN to commission a study to determine if there should be a permanent international court to apply these principles. As a result, the United Nations chartered the International Criminal Court in 2001 on the same basis as the IMT and is still investigating and prosecuting war criminals to this day. Natural law theory, universal jurisdiction, and the IMT Charter were clearly the basis for the modern ICC and its predecessors. The concept of state sovereignty, however, has not completely died. Many states challenge the ICC, including even the United States, which still does not recognize its authority on the basis of, unsurprisingly, state sovereignty. Right now, the United States is under investigation by the ICC for war crimes in Afghanistan. The likelihood that those crimes, if they exist, will ever be punished is virtually non-existent because the United States will not accept the judgment of the ICC. Still, there is a hope that the mere presence of the International Criminal Court will deter the worst atrocities that future perpetrators might envision. Right now, potential crimes against humanity and genocide against the Muslim Uyghurs by China and the Muslim Rohingya by Myanmar are testing that theory. The hope is that the presence of the court, despite the reluctance of some states to recognize it, will nevertheless deter the worst possible outcomes in future wars and international conflicts. Thanks for listening. This is Arden Eby, out.